Good afternoon, everyone, and thank you for joining us today for our webinar on combating sexual harassment in housing through collaboration. I'm Emily Flanagan from the National Legal Aid and Defender Association. All of us at NLADA are thrilled to be presenting today's webinar along with the U.S. Department of Justice Civil Rights Division. During today's presentation, leaders from the Civil Rights Division and Legal Aid of North Carolina will explore the legal framework available under the Federal Fair Housing Act to address sexual harassment in housing and discuss opportunities for collaboration among those providing direct legal services and the federal government. They will also be sharing information on the types of legal services available to address sexual harassment in housing, the proper process of identifying and referring the crime, civil rights litigation on behalf of victims, and helpful tools and resources you can use in your own work. I want to thank today's presenters, who are Tamar Hagler, Deputy Chief of the Housing and Civil Enforcement Section at the U.S. Department of Justice Civil Rights Division, and Kelly Clark, Supervising Attorney with the Fair Housing Project of Legal Aid of North Carolina. Before we begin, we have a couple of logistical items. First, we should have about 15 minutes for Q&A at the end of the webinar, so please submit your questions in the chat box throughout the presentations, and our speakers will respond to as many questions as time allows for. You can access the presentation slides and the documents referenced in today's webinar on the NLADA webpage. We will also be recording this webinar and will post the video on the same NLADA webpage as the resource in the next couple of weeks. Thanks again to our speakers and all of our participants for joining today. And now I'm going to pass it over to Tamar.
Okay, thank you so much, and thank you very much to NLADA for hosting this and for giving us such a wonderful platform to get to so many of you who hopefully at the end of this you will agree are our critical partners in this endeavor. And thank you to Kelly, my co-presenter from Legal Aid North Carolina. So I want to give a little bit of an overview of what we hope to accomplish today. We are going to start by talking a little bit about what sexual harassment in housing is, what we're talking about, and how to recognize it. We will talk about the Department of Justice's Sexual Harassment in Housing Initiative and the specific efforts we are undertaking. We will talk a little bit about the legal framework for litigating these cases. And for purposes of this presentation, we are talking mostly about the Federal Fair Housing Act, not state or local equivalent or similar laws. We're going to use a little bit of a case study through which Kelly will talk to you about how these cases present in the legal aid context in your offices and how her office worked on one of these cases, including in collaboration with DOJ. And speaking of collaboration, we will talk about opportunities for doing that. So what is sexual harassment in housing? So I want you to think about a single mom. She's got young kids, not a lot of money, maybe a prior eviction, not a lot of options. She finds a home she can afford, if barely. She falls a little behind on her rent, and her landlord says she can take care of that by engaging in a sexual act with him. So what does she do? This happens all the time in every corner of the country, in every type of housing. She fears being homeless. She fears losing her kids. She thinks, you know, maybe it will just be this one time. So some women acquiesce. They do what they feel like they have to do in order to keep their children safe. Some women resist, and some of those women are evicted, and some of those women end up being homeless. And what brings us here really to talk to you about this today is that although most of the time women who are experiencing this know that it's wrong, they often don't report it to anybody at all. If they do report it, they almost certainly do not report it to the Department of Justice, to HUD, or even to a fair housing group, but they may come to you. In fact, the story I told may sound very familiar to some of you. They may come to you in the context of defending an eviction, or getting heat turned back on, or the stove fixed, or getting benefits restored. So with that in mind, let's start talking a little bit about what sexual harassment in housing is and what it looks like. The conduct that we see and that we litigate is often egregious. It's often unrelenting, unwanted comments, advances by landlords, property managers, or others with power over tenants or access to their homes. You see on this slide some common allegations that we see in our cases, including inappropriate touching or groping, sexual touching or groping, sexual comments or advances, exposing genitals, requesting sexual acts in exchange for all kinds of housing benefits, a place to live, reduced rents, delayed evictions or foregoing evictions, repairs or other housing benefits, and taking adverse actions when tenants have resisted those sexual overtures. Some red flags to keep in mind: it is often the case that people who have experienced harassment don't discuss the sexual nature of the conduct or the sexual aspects of the conduct when they come into your office. That's especially true if they're not even coming to you to talk about that, or they come in having no intention of talking about it. But some things that come up in a lot of our cases that don't always mean that there's sexual harassment happening, but might be signals that you should pay some closer attention, are things like, you know, my landlord requires me to come to his home to pay rent, or he comes to my home to pick up rent, but he won't let me send it. My landlord or a maintenance worker comes into my unit unannounced and without a good reason. My landlord or maintenance worker is always lurking near my unit, or always commenting on my body. So in our Fair Housing Act litigation, who are the defendants? Who are the perpetrators of this conduct? Really, it's anyone with control over housing. You can see the common list of examples: landlords, building managers or property managers, maintenance workers, housing authority employees, building security guards, even loan officers. One note as we go through this presentation about gender: I will mostly be using women when I'm talking about the people who are experiencing sexual harassment, and men as the persons who are engaging in that conduct. And I'm doing that because that's what we see most commonly in our cases and what we hear most often reported. But I do want to say, and it is important to remember, that men too can be the victims of this conduct, and women can be the perpetrators. The other thing to know about the people who perpetrate this conduct is that it's rarely a one-time occurrence. It's almost always been going on for a number of years. And these, usually men, specifically target vulnerable populations, and in some cases they even build their rental businesses or their rental practices around their behavior. So for example, and this harkens back to one of the red flags I mentioned, you have landlords who, as part of their regular rental practice, don't accept rent by mail or in certain other ways, or pay to a property manager. You have to go to the landlord's house or he comes to your house. The defendants are often very dismissive about the women who are their tenants, about people generally who are their tenants. They often perceive themselves to be doing these women a favor, like, well, nobody else would rent to them, or I'm this sort of savior type because I'm giving these women who are down on their luck a place to live. And they often speak very contemptuously about the tenants that they harass. Here's one example from a deposition of a defendant in one of our cases. what about her? He had just gone through the list of women who had accused him of sexual harassment, and according to him, they were all lying. And so the question about one particular woman was, what about her that you know makes you think that she would lie? And his answer was, she's a renter. What about being a renter makes her more likely to lie? They're poorer than most people, and they need money worse. A lot of things. Does being poorer than most people make somebody more likely to lie? Yes. So we've talked a little bit about who is engaging in this conduct. Let's talk a little bit about who we see as the people who end up being harassed in a lot of these cases. You'll see on this slide, again, a list of common traits or common things. They are tenants or applicants. It can happen even before somebody becomes a tenant or even if somebody never becomes a tenant. Note that the Fair Housing Act applies both to private housing and public housing or publicly assisted housing. Speaking of which, it can, people who are harassed can be housing benefit applicants or recipients. We have brought cases involving housing choice voucher landlords. We have sued housing authorities because the harassers were those in charge of issuing vouchers, hearing appeals of denials, and those inspecting properties. It can be somebody who is applying for a home loan. And you'll see on the slide the reference to almost always the women who are harassed are very vulnerable. And what we see in that regard is the women tend to be people who are very financially unstable. They're often single heads of households. They often have a spotty or problematic rental history. They sometimes have a criminal record. They're sometimes recovering from addiction. They have not infrequently in the past experienced sexual violence. They're often moms with young kids. And generally, as you also see on this slide, they basically have nowhere else to go. They have few or no options, and many report feeling that their only choice was to endure the harassment and in some cases comply with sexual demands or be on the street. So I want to show you a few examples of how these vulnerabilities play out for these women and the women who survive this conduct and who end up being victims in our cases. Did the landlord check your credit? No. Was that something that appealed to you specifically? Yes. Did he require you to pay a full deposit? No. Was that something that appealed to you? Yes. In another case, can you describe why you had the fear of being homeless? Because I wouldn't have any place to go. Did you have any alternative housing that you could move to? No, I was there by myself. My parents were out of town. I was here with just my 2 kids. And then finally, this was in the context of a woman who was sitting in the office of a hearing officer in the context of public housing benefits. And do you agree with me that you could have left that meeting at any time, correct? Yes, sir. And the reason you didn't leave that meeting was why? Because my kids are way more important. So I figured I had to do it to get a roof over my kids' head no matter what the circumstances were at the time. In that case, applicants were appealing housing denials, and the perpetrator, it was alleged that he would dismiss fines and fees that residents owed to the housing authority if he could show them his genitals, show them pornography, or ask them sexual questions. That made them feel, as you can tell from just this very brief exchange, made them feel incredibly uncomfortable, but feeling like they had to endure it because that was really their only choice. As you know, wait lists and other options are minimal. So we've been talking about what sexual harassment in housing is. So now let's turn a little bit to how to combat it and take it on as a civil rights violation. So sexual harassment is a form of sex discrimination under the Fair Housing Act. Sexual harassment claims are traditionally analyzed under two legal theories, quid pro quo and hostile environment harassment. These are theories that will be familiar to many of you in the employment context. So this is not a seminar on litigating these cases, so if anyone's interested, we could maybe do another webinar on that. But we do want to give you some basic and important background to frame the rest of what we're talking about. So quid pro quo, a landlord engages in quid pro quo harassment by basing tangible housing-related decisions on a person's submission to or rejection of sexual advances. The conduct or request is unwelcome. The submission can be made explicitly a condition or implicitly a condition related to the tangible housing benefits. Two important things about this is it can be quid pro quo sexual harassment even if the person acquiesces. And that's often something that when women tell us their stories or when women may tell you their stories, if they acquiesce, they often feel like they have done something wrong, like they may have broken the law. And certainly for many, even if they don't feel that, there's a certain amount of shame associated with that. The other thing to know is that in the context of quid pro quo, even a single instance of quid pro quo harassment may, depending on the circumstances, be sufficient to establish a Fair Housing Act violation. Here are some examples of how quid pro quo plays out in these cases. Did he say to you that if you did these things, he would reduce the rent? Yes. Did he tell you how much he would reduce the rent? $200. Did he ever threaten to evict you if you did not have sex with him? Yeah, I think that's why he evicted me. In the next example, he called and left messages asking about the rent. Yes. You called him back. Yes, I told him I was short on my rent. What did he say? He said that I knew how to fix that. And he told her to come over there so she could talk about it. And she goes on to describe that in great and excruciating detail how she did go there. She left her kids with her sister in order to go over there, and that she was stalling. So why were you stalling? Because the reason I was going over there was to let him touch me, because that's what he meant when he said, you know how we can fix that. That's what he asked for then? Yeah, but he wanted sex. That's where it was leading. He had already said prior, he had already said sexual things to me. So the next legal theory is hostile housing environment, and under this theory, sexual harassment is unlawful when it creates an intimidating, hostile, or offensive living environment, regardless whether the harassment results in the grant or denial of a tangible benefit. So the definition you'll often see is unwelcome conduct that is sufficiently severe or pervasive as to interfere with the use or enjoyment of a dwelling, and it does not require a change in tangible benefits. So even if a person is never evicted or never has maintenance requests denied or in any other way are the tangible housing benefits changed, if the conduct is so severe or so pervasive as to be intimidating, hostile, create an offensive living environment, that can be hostile environment. The courts look at the totality of the circumstances there. Now, one note about these legal theories, we've been talking about these theories being the same ones that come up in the employment context, but courts and we recognize that the harm in the housing context is unique. That is, in the home, that's where one should feel at her safest and at her most secure. And when it happens at home, there's nowhere else to go. There's nowhere else to flee to. There's nowhere else to retreat to. And you can see this quote from the Eighth Circuit emphasizing that, the conduct occurred in the home where she was entitled to feel safe and secure and need not flee, and which makes the conduct even more egregious. There's also good language from the lower court opinion in that case. So here are some examples of hostile environment in housing. You know, the comments that he would make about how nice my ass was. He would say things like, you know, you have the best looking one on the Upper West Side. He would talk about her lips, about how he loved to watch her mouth, that she was very pretty, that she could strip on the pole and make a lot of money. And it would come up all the time. Every time she encountered him, this was a superintendent, housing superintendent, every time it was some sort of sexual undertone, as she put it, whether, as she said, whether it would be a look, a gesture, a touch, or something he said. In another example, and you can see how sometimes the hostile environment and quid pro quo come very close to overlapping or do overlap, on how many occasions approximately would you say that he offered you $100 for photographs of your breasts every time he saw me? 25 to 30, every time he wanted to take a picture. 25 to 30, yes. Did he make this offer of $100 in connection with that each time? Yes. Once he made an offer of giving me my whole rent back. Taking pictures of women, of tenants unclothed or in some partial state of not being clothed is a very common thing we see in our cases. So we've talked a lot about what sexual harassment is, how it plays out, how it presents. We're going to turn now to who can bring cases and how. And you're going to hear in a minute from Kelly about private enforcement, and then I will come back and talk to you about DOJ's role. But for now, I do want you to know that combating sexual harassment in housing is a priority for our office and for this administration, and it has the full support of current DOJ leadership. On April 12th, we announced the nationwide launch of an initiative to combat this problem. This includes DOJ's own efforts and joining forces with HUD. I'm going to talk a little bit more about this initiative and what we've done pursuant to the initiative in a little bit. But you can see that the department even tweeted about it, and the Attorney General made a statement upon the nationwide launch. So with that, I want to turn it over to Kelly to talk to you about private enforcement and the case that she worked on.
Hello, everyone. I'm very thankful to be with you all today, and for the NLADA and for the United States Department of Justice for allowing me to be part of this opportunity, as well as for you all taking the time today to check out this presentation. So I'm just briefly going to talk about private enforcement. That's most of the experience that I've had with these cases. If you can move to the next slide, please. Here, generally, you have, there's two avenues. One, within 1 year of the last discriminatory act, an administrative complaint can be filed with HUD, or with, or it can be considered duly filed if in your jurisdiction you have a FAP, a Fair Housing Assistance Program. Is basically an agency where the local ordinance or the state statute is seen to be substantially equivalent with the Federal Fair Housing Act, and that's what we're mostly focusing on, the Federal Fair Housing Act. But just wanted to say that you could file an administrative complaint with HUD, and then HUD, because there is a substantially equivalent ordinance in your client's area or in jurisdiction could transfer that complaint for investigation and enforcement to the FAP. We have 6 of the FAPs here in North Carolina. But anyway, that complaint, if it's filed and it is transferred, would be deemed duly filed with the FAP as well as with HUD. And so that has the 1-year statute of limitation of when that has to be filed from the last discriminatory act. In that, the HUD or the FAP will do an investigation. They will determine whether there's a reasonable cause that discrimination has happened, and then you can get a reasonable cause finding in your client's favor or not. If there is a reasonable cause finding of discrimination, then either party can elect to go further through the administrative process with an ALJ, or to file in federal court, or if it's been referred to a FAP in your area, then potentially to state court. If there isn't a reasonable cause finding, that doesn't mean that there's still not a strong case. It just means that they'll issue a no cause finding, and there is a certain time period when you can file in court after that. Then in federal court, or that's the next option, is that that can be filed in federal or state court. And as I speak further in my presentation, particularly about this case, I'll share why federal court was the better avenue for us in the seller's case. But that has to be filed within 2 years of the last discriminatory act under the Fair Housing Act. And so that's generally the 2 avenues that you can look to go to in your cases. Next slide, please. So this is primarily why I've been called in to share my experience. In this particular case, is Southeastern Community and Family Services. They continue to be, but at the time they were known as 4-County Community Services. And locally in the area here in Scotland County, North Carolina, it's a rural area, low-income area. In southeastern North Carolina, they were known as 4-County. That picture right there, that is of Miss Christian Seller. She was one of the 16 plaintiffs, the private plaintiffs that I, along with Christopher Braincard, with Braincard, and Craig Hensel of Hensel Law, who we represented. And Ms. Sellers, she was instrumental in getting this case kicked off. She pursued and was trying to find attorneys to help her with the circumstances that she was confronted with. So I want to give you a little bit of a background and tell you what this case was about, and also the conduct that was involved, which dovetails into the presentation that Tamar just finished about the various violations of the Fair Housing Act dealing with sexual harassment. So this case was primarily about, it was women who were being sexually harassed by men in power. Here are the allegations, and again, defendants deny these allegations, but I'll say these allegations. It involved John Wesley. He had been with 4-County, now Southeastern Community Family Services, but he had been with 4-County for many, many years, first as an inspector, and then as in charge of the, in a lead position with the Section 8 program. 4-County was started, I think, in the 1970s, if not the late 1960s. They were the main point when people needed assistance, whether it was with Head Start, whether it was with Healthy Utilities. They also administered what many of you know as the Section 8 or the Housing Choice Voucher Program, a tenant-based housing assistance that is funded by HUD. And so unlike with public housing or other housing assistance that's tied to the building, the vouchers were distributed to those clients or to those participants after they had been on waiting lists. It could be for several years, and they could take this voucher into the private market and find a place with the landlord and use it. So Mr. Wesley was in charge of who was getting off this waiting list at 4-County. And so he was in a position of power. The other defendant was Mr. Eric Pender. He was an inspector. He basically took the place of what Mr. Wesley he had been the prior inspector. And many of you already know this, but for those that may not, a tenant can be issued this voucher, which is a huge deal because, and particularly in many areas nationally, but in rural North Carolina, there's not a lot of affordable housing stock. And Fort County was the only game in town in Scotland County that administered these vouchers. There was a Laurinburg Housing Authority, which was not involved in this case at all. They administered some public housing particular areas, and there was some low-income housing tax credit properties, not many. But if you wanted a voucher, where you went was Fort County. And so Eric Pender, he was an inspector. He was a former state trooper prior to coming to this position at Fort County. And as many of you know, your client, your tenant, you can't use a voucher unless the apartment, the residence, the home passes HUD's housing quality standard inspection. HUD's not going to pay for a place that doesn't meet these minimum requirements of basically habitability. So he had a lot of power. Mr. Wesley had a lot of power about who got off the waiting list, deciding who was next up, and Mr. Pender had a lot of power about whether a residence passed inspection so the tenant could then use the voucher, because the housing assistance, the help with the rent based on the tenant's income wasn't going to kick in until that place passed the HQS inspection. The waiting list, as many of you already know, there's a waiting list, and waiting lists could be several years for these vouchers. Fort County, Southeast Community Family Services, I'll refer to them as kind of back and forth, but they're still, people refer to them as Fort County. They had a waiting list, and they also had, many housing authorities or housing agencies can have preferences. And these preferences can maybe bump people up on the waiting list. And Fort County had a point system. And so if you were homeless, you got more points that would bump you up on the waiting list. If you're a survivor of domestic violence, more points. Disabled, potentially more points. And so, and that'll dovetail now into the conduct that we're talking about. Some of what was going on here, the conduct was Mr. Wesley or Mr. Pender were demanding sexual favors in return for, one, it was to get more points so that you can then get your voucher sooner. So, for instance, we had one particular client who had already this background with domestic violence, being homeless and so forth. She also had a disability, but if she wanted to get this letter to support her getting more points, she was referred to, the allegation was referred to this man to have sex with him, and he would write the supportive letter that would get her more points so she could have the voucher sooner. There was also demands made both in the offices at Fort County as well as outside these offices in our clients' homes or at local hotels, so that they could, so the homes could either pass inspection, the HQS inspection. Particularly in Ms. Sellers' case, these demands were made. She was had just been released from prison. She was a single mom. She had family in the area that were taking care of her children at the time. She was trying to turn over a new lease in her life. She got on the waiting list for a voucher, was up for it, and then she found a place where she could rent within the standards, the payment standards that apply to her voucher, and was told, no, by Mr. Pender, no, we have somewhere else where we want you to rent. And the place where they wanted her to rent was just a pigsty. It was horrible. No way it was going to pass the HQS inspection. But you can see how that was kind of setting her up to be in this position where she's beholden to him. And she makes all these efforts to make the place look the way that it needs to look for her and herself and her children, to be in the way it's supposed to be for her. And he keeps coming over. The allegations were keep coming over, being like, well, I basically signed the papers today, but you got to do this. And if you do this for me, and implying and also speaking about what she could do for him in sexual favors, he would make that happen. She did not acquiesce. We have clients that acquiesced and that did not. And she had made some complaints and had gotten back to Mr. Pender, and basically her place then passed inspection, but she was then kept under the careful eye of what else was she going to do. It was basically, it was passing the place passed inspection, and it really shouldn't have, given how bad it was, the condition it was in. But that was in a way to, trying to get this no longer to be talked about or complained about. We also had clients where they already had a voucher. I remember one particular client, she was homeless. The home she was in with her children had caught on fire, so she had lost everything, had gotten a voucher, had the voucher for some time. Comments were made to her, but she brushed them off. She had it was a boyfriend that was staying with her occasionally, and she was called in because it said that they had evidence that Mr. Pender and Mr. Wesley had called her in, but the evidence was someone was unauthorized staying with her, and that if she performed these acts in the office, this was after hours, then she could, this allegation would come back to haunt her. And that's how it started. So it was something hanging over her head. When she tried to stop what was going on, then actions were taken in regards to her voucher, so she basically then no longer had it. And also an aside to this, as the boyfriend finds out that of these calls that are being made after hours and so forth to her, he then beat her when he found out who it was, Mr. Pender. You had some people that had lost vouchers and they were trying to get it back. There was also acts of other conduct or acts of intimidation. We did have clients that were sisters, and when it was found out one was coming forward, Mr. Wesley and Mr. Pender went to the other sister, who was not yet named a plaintiff in the case, and was like, you need to get your sister to stop talking. And it was coming to her house and making these allegations. And, she has a voucher at that point, the sister did, but, of having these employees coming to her house and threatening her and her sister, or the allegations were of these threats. We also had other conduct was just a statement, and under the Fair Housing Act, as these demands, these are considered discriminatory statements that are actionable under the Fair Housing Act. But we had one who was a client who was a property manager, and she was trying to advocate on behalf of one of the tenants for the voucher to be used at a property that she managed, and she was propositioned. So she wasn't even a voucher holder or an applicant. And so so these were a variety of conduct that this case presented, quid pro quo, the hostile environment, also as well as the discriminatory statement. So now I want to really spend some time of your time talking about who are the women and the women involved in this case. And they were remarkable and courageous and inspiring for me. I worked on the case for, I think, a little over 2 years, and got to know them, got to know many of the clients, as well as some of the aggrieved persons that the DOJ assisted. I got to know them, some very well, some just from the brief moments that I had with them, were inspired by them. Because, this case was about, this harassment that was being inflicted upon these women, but it was also, this case is about the women that came forward and stopped it. And again, some of these allegations were going back to 1989. And some of these women, they were mothers, they were sisters, they were cousins and aunts. And we had a couple of clients, it seemed like the whole family was hit, but they hadn't talked about it to each other. It was completely, these were strangers, they didn't know, but they had these common threads. But they were, it takes a lot to come forward. We as advocates, we want to do everything we can to help the clients to get this stopped. But we come into the community and then we leave. These women had to stay, and they had to endure, they had to be there. And they were, in some ways, they were easy targets. And so it takes a lot for these women to come forward, in my experience of what I've seen, and also to keep them forward, because it's a lot to put yourself out there. It's a small community. People know you. They know your name. They know who you're related to. And so it's a lot on them and a lot of pressure. So, again, these women were remarkable to me, very courageous. They were survivors. Many of them had domestic violence in their background, other abuse, had been homeless. Some of the clients were disabled. Most of the women or aggrieved persons that I spoken with or represented were, along with Chris Braincard and Craig Hensel, they were single moms, multi-generational. Some of them had been, their mothers had been, other family members had been with Fort County with vouchers. They were applicants. They were participants in the program. They were people, like I was talking about, that property manager that were associated with one of the named plaintiffs, and again, she was propositioned, as was her allegation. There was also another participant who was not propositioned at all, but she wasn't giving up on the goods of one of the named plaintiffs, and so she alleged that there were some acts taken against her because she wasn't giving information to the defendants, particularly Mr. Pender and Mr. Wesley, about what was going on with that particular client in the case. Some of these women, like Ms. Christian Sellers, they had criminal backgrounds. Many felt that they would not be believed. I had a young client, I remember, learning from her, and my understanding was that it was a big deal. Never did some of these women think that Fort County could be held accountable to this. There had been rumors for years and years and years, but because of how highly respected they were in the community and how long they'd been doing these services, they didn't think their one voice was going to make a difference. And so that tells you, you know, and someone with a criminal background, you already see them as potentially being not believed. And so there was some of that. And with these clients, it was in that particular area, I mean, they were Native American, African American, and white were some of the racial composition of these clients. It was, you know, we assisted in the private plaintiffs 16 women. There's only 15 in the caption, but we had one that had come forward prior to the mediation. We were going to add her to another amended complaint. And then you had, with the DOJ and their involvement and what they uncovered, they were able to assist. It was 71 women, aggrieved persons. There were more women. These were the ones that had come forward. But 71 women, they were able to assist with the fund that was later set up with this case. And now I want to switch to and go over and talk about how the case arrived at Legal Aid of North Carolina. And I still remember to this day, I mean, it's not that long ago, but getting the call from my former supervisor, Vilma Suarez. She had been supervising, been at Legal Aid for years, used to be a federal public defender, and then had taken over this newer initiative. Had been in the works for several years. It's our centralized intake unit at Legal Aid, are known as our helpline, but basically now our cases from our 20 offices across the state, that's how cases are opened up in our offices. It's through the centralized intake. It's generally, there's a couple of phone numbers, but there was this one main number where potential clients can call, and there's not a voicemail associated with it, and they can call and call and call until they get someone. The hours are evening, they're through the day, they get someone at Legal Aid through the centralized intake unit that can take their case to see if there's any legal issues, open up a case to make sure all the federal regulations that govern our program are complied with, and they meet our income eligibility and all of that. And so our centralized intake unit also, with our project at Legal Aid, the Fair Housing Project, there's a dedicated line, and some of y'all may have seen the pamphlet. There's an example of it, or there's a copy of it that's included with the materials here. But that number that's on that pamphlet is a specific dedicated line at the centralized intake unit at Legal Aid that's specifically for fair housing cases. And so at that number, people can call and they can leave a voice message. They don't have to keep calling to get through. And they can leave a message and people will be called back, but generally within 48 hours. We also have an online ability to have cases opened online. But at the time this case came in, it was, we had this dedicated line with our Fair Housing Project, and we had this 1-800 general number with the centralized intake unit. The centralized intake unit monitors both. So in this case, it was one of the plaintiffs in this case. And kind of step back is that Craig Hensel out of Hensel Law in Greensboro, North Carolina, filed a case on behalf of 3 plaintiffs against Fort County and Eric Pender and John Wesley in September 2012 in Scotland County Superior Court. And who had first come to him was Ms. Sellers, and then a few women came forward. One woman had come forward but then retracted her statement and was, what we saw later in the case, she was given a voucher pretty soon after she retracted her statement. And so he only had 3 at that point. So he filed on their behalf in state court, and it was the claims that were brought were toward assault, battery, negligent infliction of emotional distress, intentional infliction of emotional distress, and also like negligent supervision and so forth. Craig was primarily an employment plaintiff discrimination attorney. And so he filed this case, had been some publicity, and then 5 other women had come forward, and so we amended the complaint, now representing 8, and one of those women had contacted our main number at the centralized intake unit, so she had been calling and got through, and was calling about, her concern about her voucher. Could she get her voucher back? And Vilma's office, spoke with her, investigated, found online these articles about the case. And so then Vilma called me and called my office and alerted me about it, also about, Craig Hensel's involvement and so forth. And that's how it began. And, our centralized intake unit, they're trained on a variety of issues and claims. And so they spotted this. And it's because of one of those plaintiffs that called in. And so that's how it started with us. And going to the next part of what did we do, I'd been at Legal Aid for about 11 years at that point. I had just moved over to this statewide project. We had gotten funding from HUD to just focus on for this project for housing work. And I, along with my colleague Suzanne Chester, just filed my first sexual harassment and housing case, actually in state court up in Hertford County, North Carolina. We had done some research and talked to attorneys that practice both in federal and state, and it was thought that we might get more of a sympathetic jury in state court. So we had filed our first case dealing with this issue. My organization had filed other cases in the past. This was just my first one. And so I was really green when it came to this. And so I did reach out to Craig. I passed along the resources that I had about these type of cases because we had pulled sample complaints from the DOJ's website, from Braincard and Braincard, from folks like Diane Citrino and elsewhere. Jury instructions was giving him that to look at, as well as giving him some resources about voucher and the voucher program, because that is something I was not green in. I knew about that. And so reached out to him, and then within a month I had gone to a NAFA conference in DC, and Christopher Braincard was there as a presenter, and I approached him after his presentation and asked if he might be willing to speak with Craig, given their experience. And so he did, and then he convinced Craig to reach out to my office to co-counsel, which we then got involved in the case. We also, at that time, had been involved in a limited capacity with the DOJ case that was in Beaufort County, North Carolina. And we were asked to help with some responses to discovery on behalf of the aggrieved persons. And so I had made contact with them, and I had been told, Kelly, if there's ever a case, you see another case, reach out to us. And that's what Craig and I did. And then after that, the DOJ started an investigation, which we're very very thankful for. So I was reaching out to these, to the DOJ. I was reaching out to Chris Braincard. Chris then, convinces Craig to ask Legal Aid to get involved. We do. We then move to amend the complaint in state court to include the Federal Fair Housing Act claim. And we didn't change any of the allegations. Defendants consented, I think obviously because the case law was on our side, but I think up their sleeve is that they were looking to remove the case to federal court, which we were excited when that happened. They consented to the amendment. They didn't tell us they were going to remove it to federal court, obviously, but during that time while we're moving to amend, we're also then going with the DOJ down to Scotland County. When they were coming in, they wanted to talk to our clients. And so, and I can talk about more of that in just a little bit when we get to that slide. So we were doing that kind of background work as we're waiting for the motion to amend to be granted. And then once it was granted, then defendants removed the case to federal court, which, again, we were very excited about, because if DOJ was going to file, what we understood is that they would not be involved in the state case, they would file in federal court. And there's other advantages for federal court, but that was huge. So we were very excited because that meant that if the DOJ did file a case, hopefully then our cases would be consolidated. Because this, it's a huge deal when you have the United States of America as a plaintiff against these same defendants. Not only to us, but particularly to our clients. And these are our clients that, with their vulnerabilities and with things potentially in their background, they're not as much believed, right? But if you have the United States of America behind you, that's huge. And so that's how the case came to be with my office. What did we do? We were reaching out, trying to make these connections. Once the case was removed to federal court, as kind of a backstory, when I did approach Braincard and Christopher Braincard, and in addition to them convincing Craig to let legal aid co-counsel with him, Braincard also wanted to teach my organization how to do some of these cases, how they do them. And so they got involved in that case that my colleague Suzanne Chester and I had first filed. And so we were actually in depositions in that case when we got the news that the case had been removed, the seller's case had been removed to federal court. And then quickly thereafter, we approached Chris to say, hey, could Braincard get involved in this case too? And they did. So then now we had 3 lead plaintiff's attorneys on the case. And many of you all know Braincard, you know what they obviously bring to the table if they're one of your co-counsels. So we were very excited about that. So in the meantime, we were defending, preparing clients for depositions. We were answering discovery. When Chris got involved, we really then were throwing the hammer down, and he really was, issuing out even more discovery and taking the depositions. I took the deposition of John Wesley, of other employees. We were tracking down more survivors of this, and so we were trying to get more sources of where we could find these survivors, and that was through other rental agencies, other lists that the Fort County had of other applicants and people that had, and participants. In the Section 8 program, we were reaching out to Laurinburg Housing Authority to find, people on their list because maybe they had been victimized in the past by this. We also, I would say a big part of the role, or a big role, was that, and I talked about how it takes a lot to come forward and then also a lot to stay forward of these women. And so, in my background of legal aid, and I'm sure with your background, there's a lot of issues that can come up in the case. And the biggest is we wanted to keep these women to stay forward because they have a lot of stresses in their life, more than many of us may have, or maybe some of us have experienced the same. But there were, I don't want to say I was like this cheerleader, but I was trying to issue spot to keep them in the game, to keep them in the case, because the other side, it's easier for them if these clients can get picked off. If, for instance, had a client who was very ill, her Medicaid was terminated. It was appealing her Medicaid and getting that reinstated to keep her in the game. Now, I don't want to say this was a game, like this wasn't real life, but to keep them in so their story could be heard and not because of these other reasons. Or a client whose utility is being cut off. So intervening with that. It's not to say that we can totally make a difference, but if you can, we know as legal aid attorneys and that what happens if the utility is shut off, how that can jeopardize the voucher. So trying to step in and trying to help. It's to try and take some of the stress off the client so they can stay in the case and participate. It was also, helping with transportation, lease terminations. In the middle of this, there was a termination of one of our clients, the housing assistant payment contract, which meant that then there wasn't going to be the assistance with the voucher with the property. We got involved in that. We also got involved in another client. Her voucher was being terminated, supposedly for other reasons, not related to the case. We appealed that, had a hearing. All of that, I would say, a big part was just trying to keep the clients in the case and aggrieved persons in the case. I remember going to, a aggrieved person had some difficulties. I remember going to criminal court, and I don't do a lot in criminal court, but I went to criminal court asking for a continuance so she could be deposed and for that. So those were some of the things that legal aid did. Discussions with the DOJ, moving on to that. I've already talked a little bit about that, how we reached out to them through some established contacts that we had working on another case with the DOJ, and they were just wonderful. Jessica Crockett, now, probably know, some of you may know her as Jessica Crockett. She's Jessica Clark, also with an E, I have to add, which is a great thing. She came down along later than Beth Frank and interviewing the clients, interviewing other people. The investigation that they were able and what they were able to uncover was phenomenal. They then filed, after the case was removed in like May 2014 to federal court, the DOJ then filed their own case in December 2014. And before they filed, we were sharing with them, depositions, the non-confidential parts, other evidence that we had, and we were very mindful of this list of the common interest privilege, meaning, and that was, it's a privilege that can be invoked so that basically, our client speaking with them, the argument is that would not breach the attorney-client privilege that we had going with our clients, and for that protection, because we have a common interest in the defendants that we're suing and in the claims involved. And so it was very mindful of that. I remember in one deposition of one of our clients of Chris and Craig, our client, of invoking the common interest privilege and instructing my client not to answer when defendants' attorneys were asking what they had spoken with the DOJ about. And we didn't have to duke it out about that, but because then the case later resolved, but just being mindful of that. And during the investigation, the DOJ's investigation, when you want your clients to speak with them because you want this case, you want their involvement and what they bring to the table. They bring so much to the table and what they can do. I mean, again, this is the United States of America that's filing their own case against these defendants. But just to keep mindful of that privilege also in these interviews. It was sometimes we had interviews in the car because they were family members that were in the house, and so it was Jessica, it was Beth, it was myself, and the client in the car. They also, DOJ, were doing their own investigation, so they were able to, interviewing other aggrieved persons. We were trying to find other aggrieved persons. I would meet with them at their houses to get some of their statements or to interview them. It was definitely a lot, but it was so worthwhile. So that's all I think I have on my part of this part of the presentation. Well, I guess I could tell you the end of how it resolved. I think that would be helpful. Ultimately, the case went to mediation. The cases were consolidated. We went to mediation before the cases were consolidated, but we were all there, the DOJ, the private plaintiffs, and defendants. And it finally resolved, I believe it was in August 2015, or maybe in July 2015. We had 2 days of mediation in Pinehurst, North Carolina. And total amount of compensation for private plaintiffs, as well as a $1 million fund that was set up for future survivors to come forward, other aggrieved persons. And there was also injunctive relief, that there was an independent manager set up to monitor the Section 8 program that was administered now by Southeastern Community Family Services. Mr. Pender and Mr. Wesley were permanently enjoined from managing property, and there was training and so forth. It was a total, I believe, it was $2.7 million that was then distributed. That's including the $1 million fund for the other aggrieved persons that came forward. And the DOJ they were the ones that were in charge of getting the court's approval of interviewing and distributing those funds, the $1 million fund to the other aggrieved persons in that case. I think that's all that I have. All right. So back to you, Tamar.
Thank you so much, Kelly. I think you can tell by the passion and the details how carefully this case was litigated and how powerful the stories were. So I want to turn now to talk about a little bit about what the Department of Justice's jurisdiction is. You heard a little bit about the ability for private enforcement. So a couple of key things about DOJ's jurisdiction. Mostly what we're talking about in these cases are the ability to bring pattern or practice claims. DOJ has independent authority to bring those claims, meaning we don't need a referral from HUD. There's no exhaustion requirement. there doesn't need to be a formal complaint of any sort. We need to determine that there's a pattern or practice of discriminatory conduct, in this case, sexual harassment. As we already discussed, in sexual harassment cases, that's very often the case. There is another path to DOJ that I won't talk a lot about, but that you should know, and Kelly also talked about it a little bit, which is that if a complaint is filed with HUD, an individual complaint is filed with HUD, and HUD determines that there's reasonable cause to believe that discrimination, in this case sexual harassment, occurred, they will issue a charge of discrimination. If either party to that complaint, either the complaining party, the complainant, or the respondent, chooses or elects to go to federal court, that case then comes to the Department of Justice, and we file that case on behalf of the HUD complainant. We get those cases a lot from HUD. In some cases, and very often, we add a pattern or practice claim so that we can bring in other people, and in some cases, we have not found other people. So now I want to talk about the statute of limitations for Department of Justice actions, and I know that sounds like the most exciting part of this presentation, but I do want to pause on it. It's important, so if you've tuned out, tune back in. The Department of Justice's statute of limitations to bring lawsuits, and I'm actually going to start at the bottom, because to bring injunctive, this slide, to bring a case to get injunctive relief, there is no statute of limitations for Department of Justice action. We have 5 years from the discriminatory conduct to get a civil penalty. That goes to the United States Treasury. But most importantly and meaningfully, in order for us to bring a pattern or practice case and to get damages for aggrieved persons, which is the term that victims or survivors, that attach to victims or survivors in these cases under the Fair Housing Act, we have 3 years from when we find out about it, basically. So 3 years from when the relevant official at DOJ has cause to believe that the defendant was engaged in a pattern or practice of housing discrimination. Effectively, that's the discovery rule. And so it's 3 years from when we learn about it. And that's important for a few reasons. We have litigated, and the courts have confirmed that when we bring a pattern or practice claim, it is a single claim. It's a pattern or practice of housing discrimination, and as long as that pattern or practice claim is timely, which, as I've just said, we brought it within 3 years of finding out about the conduct, then we are able to recover damages for women or for others, no matter how far back in time the discrimination or the harassment happened to them. So you heard, for example, Kelly talk about that in the case involving Southeastern Community and Family Services, there were women that this had happened to way back in 1989. Those women would not have been able to bring their own claim. They wouldn't have been able to file an administrative complaint. They wouldn't have been able to file a complaint in federal court. And so one of the really powerful tools that DOJ can bring to the table in the right kind of case is if you are aware of individuals who have experienced harassment, but it was more than 2 years ago or more than a year ago. Okay, so let's talk a little bit more about these cases. So first of all, where is this happening? This is happening everywhere, every corner of the country, I'm sad to say. It happens in rural areas, in suburbs, in big cities, in small towns. It happens in small apartment complexes, in big high-rises. It happens in mobile homes. It happens in single-family homes. It can happen in shelters. As you've heard, it can happen in public housing as well as private housing, basically everywhere. So I want to turn a little bit to how these cases are litigated by the Department of Justice. And again, I'm really just highlighting a couple of things that I think are particularly relevant to the conversation here, to how how, when, and why we might collaborate on these cases. So this is, I know it's small and a little bit hard to read, but this is an example of a very recent complaint we just filed a couple of weeks ago in the Northern District of New York, alleging conduct in and around Oswego, New York. The reason I'm putting this up here is so that you can see that we, which may be a given, but we bring these cases in the name of the United States against the defendant. So, and in our pattern of practice cases, the women who we've identified as of the time of filing the complaint are not identified by name in the complaint. So their names appear nowhere in the complaint. If you take a look, you can look at this complaint and others on our website, and you'll see that we describe the conduct in fairly general terms, and in some cases in fairly explicit terms, but in such a way that it is not identifiably connected to a particular woman. I noted before that we also bring cases upon referral from HUD when there's an individual case and an election has been made. Those cases are a little bit different, and the complaining party is identified in those cases. In those cases, the fact of the HUD complaint and the HUD process and the HUD election is jurisdictional, and so those specific facts are pleaded in the complaint. It is still brought in the name of the United States, but the names appear in the complaint. We often in our cases, we get a protective order. The protective order almost always addresses prohibition on contact between the defendant and the bad actor in particular with, in this case, there were also private plaintiffs, witnesses, or people that we have identified as aggrieved persons. I said defendant or other because in the case in the case example that you see here, the defendant was the harasser, it was the landlord, but there are sometimes where, the defendant might be the housing authority in addition to the individual bad actors, for example, or it might be a landlord and it may have been the maintenance worker who did the harassing, and so, that would dictate how this provision is written. There are very often carve-outs, and you'll see that here for dealing with current tenants, people who are current tenants, and depending on the specific circumstances of the case, that dictates how that carve-out is written or even whether the carve-out is written. Okay, so I want to talk also a little bit about how these cases are resolved. Like most civil federal court litigation, we settle the vast majority of these cases. These cases, by comparison to some other Fair Housing Act cases, they do tend to litigate much closer to trial and further along in discovery than many other cases, partly because a lot of times these defendants take it very personally, as you might imagine. So we have had these cases go to trial, and again, I think it's fair to say more likely to go to trial than other Fair Housing Act cases that we litigate. But nevertheless, we do mostly settle these cases. Here is one recent example, and you can see that the typical provisions include compensation for aggrieved persons. Those are the monetary damages. Monetary damages are mostly emotional distress damages, although sometimes they are provable and proven out-of-pocket expenses. You'll see that we also get, most of the time, a civil penalty for the United States. We also, the injunctive relief is almost always very important in these cases. A very common provision in our cases involving landlords or property managers is a permanent prohibition on the individual directly or indirectly performing any tasks that involve directly interacting with tenants at residential properties. If the defendant is a landlord and continues to own properties, we require that that he engage an independent manager to deal with the tenant. So we don't require that landlords cease being landlords or cease being property owners or engaged in that business, but we do require that if they do continue in the business, they hire an independent manager. We also, as a part of the injunctive relief, include a no contact provision that's similar to the one I talked about in the protective order. So these are cases, these are cases that the Department of Justice has brought pretty consistently over the years and across administrations, but we really knew that we were seeing only the tip of the iceberg. And one of the reasons that we knew that is because inevitably when a case would make its way to us and we would go start knocking on doors and trying to find people and talking to friends of friends and otherwise doing the legwork to find people, we would find people who had been harassed by the same individuals with the same kind of conduct going back years and had never reported. So we wanted to try to address in a more targeted, affirmative way this problem of underreporting. We went back through a lot of our records. We talked to a lot of people, including a lot of you, and we confirmed that many survivors and those who encounter them aren't aware that sexual harassment in housing is illegal under the Fair Housing Act, and in fact, even police departments, law enforcement officers don't know that. I mean, we've had situations where the women reported to police, and I should say some of our cases did include, not through our work, but through local work, criminal prosecutions of sexual assault. But those are the rare cases. Mostly when the women go to the police, they end up hearing that this is a civil matter, that there's nothing that they can do, or that it's he said, she said, or that it doesn't rise to the level of a criminal sexual assault. And they also don't know that there might be a remedy in the civil courts. So we launched last year, and then, as you saw, recently expanded nationwide, an initiative to combat sexual harassment in housing. The goals really are to increase awareness of the problem of sexual harassment and our ability to do enforcement work in this area, and to encourage more reporting to DOJ. And we're also working with HUD to utilize their tools and leverage their presence, especially in the public housing context, but really beyond that, to combat this problem. We are working to develop partnerships. Collaborating with legal services is really a key component of this initiative, because this is where people go. This is where people show up. We know that many victims, many survivors won't report the conduct to us, but they may report it to you. So one of the things, when you see it on your screen, just little clips, we have a dedicated website now, to a dedicated web page, I guess, really, to the issue of sexual harassment in housing. The image on your screen shows that there's a way you can go to the website and click and report the conduct. It also includes the 800 number that we screen. Another important part of this initiative and our ability to collaborate is that there's a resources page. Some of these resources are really outward-facing, client-facing, survivor-facing. We have on this page, what you see on the bottom is a palm card. So this is the front and back of a card that's a little bit bigger than a business card size. We have those available. It is all downloadable on our website, but we realize those are a little bit hard to print, and if you're interested in putting some in your office or using them, we can send you some. We have those palm cards in English and in Spanish. You'll see we also have flyers on our website that are available to download. These are available in, well, the one on the left, the blue one, is available in numerous languages. If you find that there's a language that you really need, that you think is important to have, that's not available, please let us know. There's also, this is really just meant to give you a visual. I know you can't read this. This is an info sheet that is available on our website in English and Spanish. It's really meant to be a resource to you during intake or otherwise, in terms of, you know, it hopefully captures a little bit of the basics of what I've talked about and what Kelly has talked about today, which is who can be a victim, who can be a perpetrator, how does this usually come up, what are some red flags, and then what to do if it does come to you. And of course, by the way, if you have any feedback about this or something that would be helpful to you that isn't available already, please let us know that too. So I want to take just a couple of quick minutes to talk about opportunities for collaboration, and then we can go to our Q&A. One of the real opportunities, I think, for collaboration is to work together to do the education and the outreach about this issue, and Kelly may have some things to say about that too. But the image that you have, the image that you see, is also something that's available on our website. It's a partnership toolkit. This includes more information about sexual harassment, our enforcement authority, and it has some ideas for how to get the word out about the issues, including and especially through social media. Another way for us to collaborate is by getting referrals from you if these cases come through your door. One thing that I would say about that is that we understand that the legal services community varies a lot in terms of the kinds of things your offices can handle and the kinds of things your offices do handle. As you heard from Kelly, their office gets a fair housing grant and does fair housing work, and I know a lot of you do that as well. We are not looking to take cases away from offices if they're able to be addressed in your office, but what we are hoping to do is, if you either come across one of these kinds of situations and it's not something that your office can address, you know, to have that person call us or to reach out to us. And also, if you are addressing it on behalf of individuals, but you learn through that work that there are many others or even a few others that have experienced the conduct, and especially if they've experienced it outside of the time limits for private individuals to pursue justice, to call us in that case as well. The other thing I would say about this is that even if you're working with somebody who is very hesitant about talking to the Department of Justice, which, let's face it, I can understand. You know, it makes sense to reach out to us and to talk to us about what you do know, depending on what you know and how much you know, and whether the individual might be willing to speak with us, even if it's with you on the phone without initially giving us any names or anything. It is helpful to us because there may be situations where we know enough information to know that we really should look into this, and there may be others who are, for whatever reason, better positioned to come forward to DOJ, and that there's still something we can do about that particular landlord or housing situation. You know, in terms of opportunities for collaboration, you know, Kelly also talked a little bit about some of what was happening to women in her case collaterally at the same time, like getting benefits, having utilities cut off or not being able to get utilities, or having social services, needing help with social services. Those are things that we can do very little about, especially if the conduct isn't at the hands of the defendant. So we can't go into state court or otherwise help that person in those kinds of interactions with courts or other administrative bodies. And so we really do rely on partnerships with legal aid offices to be able to do that work if that's something that they have the capacity to do. The opportunities for collaboration also reach beyond the litigation and after the litigation, and two quick things that are, I think, worth mentioning is that, as you know, or as you may suspect, when we recover monetary damages for aggrieved persons, getting a check for a good amount of money can have impact on all kinds of public benefits. That is also something that we are not able to help women with directly. And so we regularly do refer people, generally speaking, to invite people to find private counsel or to look to legal aid. But very often we have worked with legal aid offices very specifically because either they were involved in the case, maybe they referred it, or maybe we've just talked with them as we've been going through our litigation. But very often those partnerships are really key, and in various ways, sometimes very formal, sometimes less formal, legal aid offices have worked with the individuals who have gotten money as a result of some of these cases. And then finally, you have an example up here of a provision in one of our settlements that provided for the opportunity for the women who'd been unlawfully evicted as part of the sexual harassment to get those eviction and unlawful detainer records stricken. And what you'll see that the way this is written is that it required the defendant to do certain things to cooperate and to do everything necessary, including showing up in court. But it was not the defendant who, went into court on behalf of the women. It was Greater Bakersfield Legal Aid who did that with us and with these women, and who helped bring what was really very important relief to these women, and that we would not have been able to do on our own. So with that, there's information about how to contact us, our website. You'll all have access to this and to Kelly's and my information, but I think it's probably time.
Okay. Well, I do want to thank everyone again, and thank you to Kelly and to Tamara thank you all for hanging in there with us, and thank you to Kelly and Tamara for all of the knowledge and experience that you've been able to share for us. I think I mentioned earlier that this PowerPoint and a link to the resources are available on NLADA's website, so you can find that there. I will mention two other things. Is one that we are working with Tamar and others at CRT, the Civil Rights Division, to really bridge this initiative with legal services, and they are very open and want feedback from legal aid in this area as they develop more resources and build out the initiative. So two upcoming opportunities, I think, to see Tamar in person and work on that is, one, if anyone's attending the Equal Justice Conference in a few weeks, Tamar will be hosting a networking lunch to provide that forum to give kind of some open and candid feedback on the initiative, or bring some concerns or maybe some of the issues you've been seeing to her. And then at NLADA's Litigation and Advocacy Leaders Conference, which is in July, Tamar also will be hosting, I think, a more in-depth session about the litigation of some of these cases. And with that, before I close out, I will just ask Tamar and Kelly if you have anything else you would like to add while we have this line open.
No, just thank you so much.
Thank you very much.
Okay, thank you. Thank you again, everybody. And again, you can find all the resources on NLADA's website.